Transgender boys are suing the University of Missouri system over its decision to stop providing them gender-affirming care treatments. The university's decision comes after a new law bans such care for minors. Missouri Capitol Bureau Chief Joe McLean gives us a closer look at that case and what it could mean for Missouri health care.
The law banning transgender care came with an important exception. Those who were already receiving treatment could continue doing so, but the university opted to not offer any treatment to anyone whatsoever. And that's why these two boys say the university violated their rights.
There's a provision of the Affordable Care Act that prohibits any health program that gets federal financial assistance from discriminating on the basis of sex or race or disability.
Andy Hirth says that's why his two clients sued the UM system. The two are not named in the lawsuit. One is 17 years old and has been taking doctor-prescribed testosterone for more than a year. The other is 10 and started his doctor-prescribed puberty blockers about a year ago. They argue the university has no reason to stop providing the treatment.
The people that are in the best position to know what treatment their kids need are parents and doctors. They don't need people in Jefferson City making decisions about what treatments are appropriate and what treatments are not.
Hirth's lawsuit argues that by stopping the treatment, the university put the boys' health at risk. But a spokesperson for the university said that MU Health would be put at legal risk if it continued because of provisions in the law which allow any patient to sue for big bucks if something goes wrong.
Specifically, the minimum amount of damages could be in the neighborhood of $500,000, and that number can also triple depending on what's found. Additionally, individuals could file suits many years after their care.
Up to 15 years after their care, in fact. The sponsor of the law described gender-affirming care as evil. His critics have said the way the law is written is meant to threaten providers and motivate them to deny treatment without actually banning it. This lawsuit was filed in federal court, and an upcoming hearing will decide if treatment can continue while the court battle is fought out. In Columbia, Joe McLean, First Alert 4.